Take a look at hearsay now. Any, right? Any statement made by anyone, anywhere, other than right here, right now, in this proceeding, is hearsay, if it's offered to prove the truth of the matter asserted therein. If so, it's hearsay unless it's a party's own statement that the adversary wants to offer, that the other side wants to offer against you. What is often referred to in the books as an admission, but that's a real misnomer because it doesn't need to be an admission. It's any statement the other side made that the adversary wants to offer. Any out-of-court statement. Let's take a look. Any statement made by anyone, anywhere, other than right here, right now. Right? He said, she said, even I said. A common misconception is that a witness who gets up there and testifies on the stand can repeat what they said earlier in time. Absolutely false. Only a certain group of cases where that is actually true. And if you do the analysis right, you'll get them right. Witnesses cannot simply repeat what they said earlier in time. Any out-of-court statement. Okay, statements. That's a statement, right? Statements don't need to be words that come out of my mouth. Nod of a head, a point, those are statements. What time's the clock say it is? 5:09. Things don't say things, okay? Whether it's a speedometer, whether it's a radar detector, whether it's the clock, when we talk about hearsay, only people make hearsay statements. Now, a great example I always liked is the dog, the tracking dog that runs and chases for 2 miles and finally finds someone and stands there like this and points in the house. The dog making a statement that the accused is inside there or that the culprit is inside there. No. Dogs don't talk, right? Newsflash. Only people make statements. So that's, if you get something like that, recognize it. That's easy then. Only people make statements. But this and this are statements. If offered to prove the truth of the matter asserted therein. The most difficult one we get, right? Offered to prove the truth of the matter asserted therein. Again, some common misconceptions. It helps. Of course it helps. That's the way the process works, right? I offer stuff that helps me and hurts you. That's my job. So when we sit there, we say, but it helps him make his case. Of course it does. You think I'm going to offer stuff that helps you make your case? So forget whether it helps the underlying case. That's really not relevant. And that's always what we say. Oh, it's that's another reason, by the way. Any of these answers say self-serving. Scratch it out. Wrong. Why? Of course it's self-serving. That's the same rule. Yes, it's self-serving. That's what I'm supposed to do. It's not a basis to exclude evidence. Out-of-court statement offered to prove the truth of the matter asserted therein. Okay, so offered to prove the truth of the matter asserted. I always have to box the statements. So the statement is, Mr. Smith, you have 6 months to live. Your cancer is very aggressive. So, Mr. Smith, you have cancer. 6 months to live. That's the truth of the matter asserted within the statement. So, Mr. Smith goes out, lives like you would live your last 6 months, piles on his credit card debt, travels the world, comes home, 6 months and a day, decides to wait, 30 days goes by, credit card bills come in, nothing's happening. Now getting a little worried that he's not going to die. He goes see his doctor. Doctor double checks the scan, says, hey, great news. I screwed up. You're going to be just fine. Comes to see you. You say, maybe I can pay off those student loans after all. And you file suit. And you sue the doctor, Dr. Jones, and you sue his hospital, General Hospital. and you want to offer the statement that the doctor said. You sue the doctor, obviously, in the hospital for malpractice. Some form of torts probably in there, too. Intentional infliction of emotional distress, God knows what else. And you want to offer the statement that the doctor made to you and your lovely wife. So, first of all, if you wanted to offer the statement, anyone who heard it, right? I don't need the speaker. I don't need anyone else other than someone who has personal knowledge of the statement. So I don't have to call the doctor. I could even put me up there to say, if I am Mr. Smith, but Mr. Smith has bias here to testify. His self-interest. He could lie. Shouldn't that exclude him from testifying? No. Right? Anyone who heard it is the rule. Anyone who heard it can offer the statement. So, but he's going to call his wife, who wouldn't lie for him. But we can get to that on cross-examination. She gets up there to testify. What did you hear the doctor tell your husband? Objection. Hearsay. Well, first of all, let me try this. Objection. I'm new at this. Privilege. No, not a doctor-patient privilege. Not a husband-wife privilege. Why wouldn't it be a husband-wife privilege? Right, it's not a communication between them, and it's also not confidential. There's a third person in the room that would destroy, even if it was a communication between them, which it isn't, you would lose the benefit of that with the third person in the room. Okay, back to where we knew we were going. Hearsay. Out-of-court statement, is it? Yes, right? Offered to prove the truth of the matter asserted therein. Take a vote. It is not offered to prove the truth of the matter asserted therein. Raise your hand. Only those with their hands up are 100% correct, right? Why? Why is he offering it to prove that he had 6 months to live? No. When we say it, the definition is just what we talked about. Is it an out-of-court statement? Yes. Offered to prove the truth of the matter asserted within the four corners of the statement. What is the truth of the matter asserted within the four corners of the statement? Mr. Smith, you have cancer. Is that why he's trying to offer this statement? No, why is he offering the statement? Well, okay, you're getting to the legal conclusion, but tell me what he wants to prove. Simply what he wants to prove by offering the statement. No, forget misdiagnosis, what the rest of you are saying. That the doctor said this statement, right? That's all he wants to show right now. The doctor said this. This is what he said, right? That's all he wants to get in. And he's got to get it in because it's the core of his case. And that's where I think some of you are saying, yeah, but he's got to get it in because it's that important to his case. That's not what makes it hearsay, right? That goes back to it's self-serving. It helps. Of course it does. The question becomes, is he offering it to prove the truth of the matter within the statement itself? If so, it's going to be hearsay. But if not, we are done the analysis on hearsay. Is he offering it to prove that he had cancer? No, he's offering it to say, this was said to me. At some point, in order to succeed on his case, he's going to have to also show that it was false, and that, you know, with negligence or whatever, it shouldn't have been said, yada, 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 and I suffered as a result of what was said to me, right? That it's malpractice. But the first step he's got to prove is simply that it was said to him. It's an out-of-court statement, yes, but it is not offered to prove the truth of the matter asserted therein. It is not hearsay. The analysis is over. Now, tell me why, under the present fact pattern, that is not a declaration against interest. There's no showing in the fact pattern, as we have presently, that the doctor is unavailable. In order to get what we call a declaration against interest, you must show that the declarant's unavailable. We'll come back to that, but I want you to start to think about a very, very important distinction between what we call, and this is where we're going next with this, assume you got this part of the analysis wrong. You said, I think it is the truth of the matter asserted therein. So it's hearsay unless. Is it a party's own statement? Yes, who made the statement? The doctor, and under our fact pattern, we are suing the doctor. Who's it being offered by? The plaintiff, the opponent. Can the plaintiff offer anything the defendant said? Yes. Why? Because that's the rule, and it comes in as non-hearsay. Right? So even if we got it wrong when we said it's the truth of the matter asserted therein, it becomes a party's own statement offered against a party. Now, the rules and your questions make reference to a party's own statement offered against a party as what we call admissions, or what they call admissions. Now, unfortunately, to me, it's a misnomer because it doesn't need to be, under the case law, a real admission. It can be any statement that the plaintiff or defendant made that the other side wants to offer. And unfortunately, by using the word admissions, we start to think declaration against interest. And so what we have to start to do is really differentiate them. A party's own statement offered against a party is any statement the other side made. And that's the only condition to offering it is, did the party make it, and does the other party want to offer it? Done. That's what they call an admission. On the other hand, a declaration against interest, the first big test is the declarant unavailable? If the declarant is not shown in the fact pattern to be unavailable, that door to the 804 exceptions isn't even open. So we don't even think about it. Because quite often you will see admission, A, admissible as an admission, B, admissible as a declaration against interest. Youch. Declaration against interest, the witness, the party must be, not the party, the witness must be unavailable. Admission must be a party. Okay, those are two big distinctions. Now, back to our question here. We said if we got it wrong that we say, well, it's a party's own statement offered against a party. That's fine as to the doctor. But you are also suing the hospital. How do you get it in against the hospital? Statement of an agent made. The doctor is an agent for the hospital. And your argument is the statement, either the doctor is authorized to speak or the statement concerns something within the scope or course of that agent's duties. I would think in this case you probably at least have the latter, since the doctor is treating at the hospital and the like, while the hospital in almost all cases will disclaim authorized to speak. That's a real red herring too, by the way. After the fact, someone screws up, I'm always going to say he was not allowed to say that, right? Of course. That's a red herring. I don't care what you say after the fact he was authorized to speak about. The question becomes, was he authorized at the time, or was it something concerning the scope or course of that agent's duties? If so, it comes in, and it comes in to bind both the agent and the principal, right? Both the doctor and the hospital. Now, the other example, historically, we have used on often to prove the truth of the matter asserted therein is the argument, someone says, Coyne is a thief, and I sue for defamation. Right? Brian says, Professor Coyne, you're a thief. And I sue Brian for defamation. He says it right here and now in front of all of you. Professor Coyne. Say, no, I'm not. And then I hire Professor Malaguti to go sue Brian for defamation. And I want to offer the statement that Brian said in front of all of you, Professor Coyne's a thief. So who do I call? Anyone who heard it, right? Anyone with personal knowledge. That's a simple rule, but we've got to remember that. Because at times the question's going to tug you and say, well, you got to get Brian. You got to give Brian a chance to explain or deny what he said. No. Anyone who heard it has personal knowledge of the statement. Ralph's tape recorder. Do we need that? No, no, no. All we need is someone who heard it. I don't care whether it was taped. I don't care whether there was notes. If you have personal knowledge, and that's one you've got to watch out for, by the way. If it happens to be the videotape, you're downstairs watching the videotape at some time, and you say, geez, the videotape, I wasn't there for class, but Brian called Professor Coyne a thief. At that point, your source of knowledge is the tape, and it becomes a best evidence problem. You didn't see it with personal knowledge. You're trying to prove the contents of a writing, recording, or other document. The rule is produce the document, unless you can explain why you can't. But all of you who have personal knowledge, who are here when he makes the statement, any one of you can offer it. And we say, what, if anything, did Brian say to Professor Coyne? Objection, hearsay. Out-of-court statement, yes. Offered to prove the truth of the matter asserted therein. Excellent, right? Much better. No. No. Even though this helps, yes. Even though this is central to my case, you bet. Am I offering it to prove that I am a thief? Absolutely not. Non-hearsay. You know what the treaties sometimes call legally operative facts. The facts, the statements themselves have legal significance. But they are also perfect examples, in my opinion, of not offered to prove the truth of the matter asserted therein. A lot of times it's like this, that simply that the statements were published, or that there are other reasons why this or that was said. You know, the bookie joint examples that we see quite often when someone calls and says, give me $100 on the Buccaneers by, what's the line now, 3.5, 4, Tony? 4? You know, something along those lines. That we're not offering it to say that the person called to say $500 on this or that. What we're offering it to show is that that someone believed that the place was used for a bookie joint. Not offered to prove the truth of the matter asserted therein, it is non-hearsay. Okay, out-of-court statements. Now, we got that all down. We know statements means gestures that are understood. We know gestures means words that come out of my mouth. And we know that statements mean writings. Any writing. You know, we have a tendency to think of out-of-court statements that if someone dresses a writing up, you know, and puts ribbons and bows, or better yet, laminates it. You know, laminates it, there's a blue seal under that with a couple little ribbons coming down. Oh my God, that's a perfect document. Hearsay. Hearsay. Documents are almost always hearsay. So don't think just affidavits, hearsay. All of those things. Don't think just because we dress it up a little bit that it still isn't hearsay. It is. Out-of-court statements offered to prove the truth of the matter asserted therein are hearsay. Unless they're a party's own statement offered against that party. Easy enough. Agent statement. A statement made by one who is either authorized to speak or concerns something within the scope or course of that agent's duties. Fair enough. Okay, and we know now that I can have a single agent or I can have multiple agents. You know, in all likelihood, every professor in the school speaks, or is at least an agent, on behalf of the law. Okay? Party's own statement, agent statement, co-conspirator statement, all considered non-hearsay. A co-conspirator statement, in order to have that, the statement has to be made in the course of or in furtherance of the conspiracy. We can use the statements themselves to help prove the existence of the conspiracy. We do not need a criminal charge of conspiracy. If I were drafting a question on the exam, it would be a civil case, because you're not even thinking about conspiracy then. But antitrust is a great area where you see co-conspirator statements. Statement made in the course of or in furtherance of the conspiracy comes in against all members of the conspiracy. It's just an expanded agency situation. Right? In essence, we've each appointed the other as our agents. Very fertile area. Lastly, still under 801. Still under 801 and defined as non-hearsay under the federal rules is a statement made by a witness who testifies at the present trial. Okay, the witness gets up there and testifies at the present trial. And there are other statements, obviously, that witness has made. And the rule, or the question becomes, well, under what circumstances can we get the prior statements of that witness in? And first of all, if the witness gets up there and testifies on the stand, and it's a prior statement of identification, and the witness is testifying now, the prior statement of identification comes in as non-hearsay under 801. If it is a prior statement of a witness who testifies on the stand in this trial, and it is inconsistent with what they just said, the prior inconsistent statement is coming in, and it comes in for substantive and impeachment purposes if the prior statement was under oath in a proceeding, and only for impeachment purposes if the prior statement wasn't under oath. Lastly, if it's a prior consistent statement of a witness who testifies at the present trial, it isn't admissible at all, and the reason is we don't need it until there's been some charge on cross-examination that this story is recently fabricated, or it's a contrivance, or somehow they've been paid to change the testimony or alter it in some fashion, or paid at all. If you can show that the witness is under some reason to either fabricate their story or contrive it or recently conjure it up, then we can offer the prior consistent statement of the witness. You know, we pay a bounty if you've always told the same story. Even if it's a lie, frankly, if you think about it. As long as you kept the same story from day one, you can get that in as a prior consistent statement if it's offered to rebut the express or implied charge of recent fabrication, contrivance, improper influence, or motive. But that always almost means then, if it's the witness who made the statement, it really should only be on redirect. It can't be on direct because the witness hasn't been charged on cross yet with recently fabricating the story. Prior consistent statement only comes in when offered to rebut the express or implied charge of recent fabrication, contrivance, improper influence, or motive. Under 801, everything we've just talked about, 801 says is non-hearsay. Now, it's very different from the common law definition. But they say a party statement, an agent statement, a co-conspirator statement, or a prior statement of a witness that's either ID or inconsistent and under oath, or consistent to rebut the express or implied charge of recent fabrication or contrivance. 801, the modern definition, says that's non-hearsay. It says these things don't count. And so if it says admissible hearsay, that's the wrong answer. You've got to find a better one. It's admissible non. Just if you want to close the loop on this, by the way, Massachusetts says the party statement, the agent statement, the co-conspirator statement, the prior statement of a witness, all of it, while admissible, is admissible hearsay. We adhere in Massachusetts to the common law distinction between the admissions, in essence, as admissible hearsay, where the Federal Rules of Evidence has decided to define that all under the new codification as non. Charlie? Yeah, yes. If someone wanted to try and get a specific, it's tried to get a prior consistent statement in on a direct examination, at that point it is hearsay. All right, and that's what happens though, is the witness is up there testifying. And the question becomes, what did you tell the police at the time of your arrest? Objection, hearsay, it is, right? The person is seeking to offer their own out-of-court statement. Unfortunately, a lot of judges misapply that and say, but he's here. He's here now. He should be able to say what he said. No, that's not the rule. It's an out-of-court statement offered to prove the truth of the matter asserted therein. Not a party, agent, or co-conspirator statement. And it's not one of these clearly defined prior statements of a witness at this point. It is hearsay and inadmissible. Now, if you've got a hearsay exception, like an excited utterance or something along those lines, you might be able to get it in. But it is, in fact, hearsay. Which, by the way, that's the last part of this. You know, we do our hearsay analysis under 801. We say it's hearsay. But you all know, I mean, this is where we're going right now, but you all know that's not where we're done. Because we got 30 exceptions we still have to take a look at. So just because we do the first part and say it's hearsay, we are far from over. Far from over. Was there another question somewhere? No, I thought so. Okay. Why don't we take a look at our, well, let's take a look at a couple of examples in this category first. Brian is beaten up. And at the time he's beaten up, they take him down to the police station. And they have him talk to one of those police sketch artists. And he tells the police sketch artist, he had curly hair, he had this color eyes, his face looked like this, yada, yada, yada. And he finishes the description, and it might as well be a photograph. And so they then show Brian a photo array. So they put out 8 photos on the picture. Brian says, picks up the photo like this, hands it to the police officer. They then establish a lineup. They put them in a lineup of 6 people. And Brian says, number 3. Brian subsequently dies of his injuries prior to trial. And the government wants to offer those things that Brian did a few hours after he was. So, which ones of those 3 are? Well, let's try. A sketch. Sketch. Nope. Which one? None of them? Okay, let's try them one at a time. The ID. We can call the police sketch artist. Classify him as an expert, non-expert, really doesn't matter. And you want to put him up there and you want to have him say what? This is the photo. But before you get to the photo, let's acknowledge what the basis of the photo is. Oh, not the photo, the sketch. This is what Brian said he looked like. Out of court statement. The sketch, yes. offered to prove the truth of the matter asserted therein. Yes. Not a party, agent, or co-conspirator's statement. Not a prior statement of a witness. Brian is dead. It is here. Have any exceptions? I got one. Past recollection recorded. No, why not? Excellent, right? That's the only one out of them all that requires availability, and not just availability, on the stand. Because that's always another misconception. Because that should fit past recollection recorded. It doesn't. Why? Because Brian's not on the stand. Past recollection recorded is out. Okay? Anything else? Present sense impression? Too late. You know, we have a question that's beyond 10 minutes and says that's too late. 10 minutes is too late. I don't know. That's what it says. Excited utterance? Not within the foundation, not within the fact pattern. I could dress that up, change it a little, and you might have an excited utterance. But someone sitting there with a sketch artist doesn't sound all that excited to me. The selection of the photo, when I pull the photo out and hand it to him, is that an out-of-court statement? Yes, right? It's saying, this is the person that did it to me. Whether he utters words or not, that's the statement. Out-of-court statement. Offered to prove the truth of the matter asserted therein. The truth is, this is the person that did it to me. Yeah. Okay, can't get... How about the photo array when I point and I say it was him? Not photo array, lineup. Right? Get that in, right? All hearsay? Okay, good. Because all of those... Now, change it slightly. Brian's alive. We put him up on the stand. Which ones of those three can come in? Prior ID? I heard someone say, not enough of you say, all of them, which in fact is the correct answer, right? And how do all of them come in? Nope, not a party. He's not a party still. How do all three prior identifications come in? As a prior identification made after perceiving a person, if Brian gets up and testifies on the stand, all of the prior identifications he made come in. And they come in under the rules as non-hearsay. Right? Why? Because that's the rule. But if he's not available, if he's dead, then we can't get any of them in. And now I think the rationale, just if you want to put it away, hopefully for good, is it's a significant confrontation clause problem, right? If Brian is saying, this is the person that did it to me, and then Brian's not there to testify, geez, you know, jury's going to take those three IDs and they're going to put him away without any chance for confrontation and cross-examination. Well, that's the way it goes. Now, I could change that fact pattern slightly so that we have something much more closely aligned to a dying declaration and would be okay. But, you know, they all seem to take too much time. I'm not so sure you have, at least in those examples, a foundation for a dying declaration, which we'll get to in a minute. Brian gets up there and testifies about his prior ID. All of them come in. Cross-examination. There's a prior inconsistent statement out there where he said, I know I told the police sketch artist he looked like that, but I was just trying to get Charlie in trouble because he annoyed me during one of the classes. Charlie never did it. Can Brian's prior inconsistent statement come in? Yes, right? Obviously it's going to come in. Your analysis only is substantive or impeachment purposes, and this statement would come in for impeachment only. Why? Because it wasn't under oath, right? One last hook on that. Brian tells the grand jury it really wasn't Charlie who did it. That's what he says. Charlie really never did this to me. Charlie wants to offer the statement. On cross-examination of Brian, the prior inconsistent statement, can he do so? Yes. Impeachment or impeachment and substantive evidence? Both, right? Impeachment and substantive evidence. A prior inconsistent statement of a witness who testifies at trial comes in for both impeachment and substantive evidence if the prior inconsistent statement was under oath. Nope. Now, why don't you have to be subject to cross-examination? Because you're going to get cross now. Excellent, right? Unlike former testimony, which had to be subject to cross, why does former testimony, the unavailability exception, have to be subject to cross? Because you're never going to be crossed again because it's an unavailability exception. The declarant doesn't need to be available, right? So this one, when we talk about a prior inconsistent statement under oath, all that's required is the prior inconsistent statement be under oath in a proceeding. It does talk about in a proceeding of some fashion. If it is, it comes in as substantive and impeachment purposes, unlike former testimony, which had to be subject to cross at the time it was given. So what that means for all intents and purposes on grand jury testimony is not as the former testimony exception, but yes, as a prior inconsistent statement under oath. Former testimony had to be subject to cross at the time it was given, either by you or someone in privity. Let's take a look at the hearsay exceptions now. Once we've made our analysis that it is in fact hearsay, then we are maybe halfway done, because there's still a whole bunch of other things we have to watch. First, what we've tried to do is group them into three main areas for you: the unavailability exceptions, the spontaneous exceptions, and the records exceptions. Now, there's still more than that, but if we group them like that, we can at least start to think about them to make our analysis. The unavailability exceptions, in order to use what we call the unavailability or the 804 exceptions, you must be at the minimum one of four things: dead, beyond the subpoena power, exercising a privilege, or incompetent. Debbie, dead, exercising a privilege, beyond the subpoena power, or incompetent. One of those four before the 804 door opens. Now, if you are one of those four things, then I can use the unavailability exceptions, which are 2Ds and 3Fs. You know how to remember the 2Ds and 3Fs as the unavailability exceptions. If you got 2Ds and 3Fs, you would be unavailable for the purposes of the bar exam. You've got to remember all five. Okay, you've got to group them together so that when we think of the unavailability exceptions, we can then apply them, because if the declarant is not unavailable, dead, beyond the subpoena power, exercising a privilege, or incompetent, then we cannot use any of those five exceptions. But if the declarant is in fact unavailable, then those exceptions are open. But understand, so are the others still. Okay, all the 803 exceptions are open as well, but if the declarant is unavailable, I open another door. So now I've got two doors to look into. That's all that means. The five unavailability exceptions. Dying declaration. You've got to be unavailable, not dead, in order to use a dying declaration. It's got to be a homicide or other civil action to use a dying declaration. And the statement must describe what the declarant believes to be the cause of their impending death while they believe their death is imminent. Declarations against penal or pecuniary interest. At the time it's made, the statement must be against the declarant's then existing penal or pecuniary interest. What's interesting about this is that from a testing standpoint, usually at the time it's offered, it's going to be in whoever's interest it is to offer that statement. And so you don't think of it as a declaration against interest. I had a case one time that we had to try an adverse possession case. And the question was whether they were allowed, the earlier people were allowed to use the property with permission. And so at the time my client bought the house, the owner said to him, I allow these folks to use the land with permission. They're good folks. They help me cut the lawn or do this or that, so I have no problem allowing them to use that property with my permission. And so he allows them to continue to do that because that's what the precedent that had been established. Well, the thing goes on for a while, and then at some point these folks decide to sue, and they sue on the basis of adverse possession, saying we've acquired the ownership of this parcel through the four elements necessary for adverse possession. So at that point, we have to defend the action, and we have to get in the fact that the earlier owner said it was with permission. Now, the earlier owner has been long since dead. So the question is, how do we get in the earlier statement that she allows them to use the property with her permission? And what we had to say, she's dead, first of all, we had to say that this was a declaration against her then existing pecuniary interest, because in essence it lessens the value of her property by allowing them to use it and continue to use it after a period of time. So what we argued is that that's a declaration against her then existing pecuniary interest at the time she made it. She's unavailable, so it should come in. It is against her pecuniary interest when she makes it. But the interesting hook here is it is obviously essential for us to get it in our case. We need it in order to defeat the adverse possession claim. That's not the test, though, as to whether it's a declaration of then existing penal or pecuniary interest. As long as it was against the person's interest at the time it was made, then it is considered a declaration of against then existing penal or pecuniary interest. Sometimes the cases in the book are where one person's on trial for murder and the other person acknowledges that the handgun was theirs. And so what I want to offer is his declaration against penal interest when he says the handgun was mine. And the reason, as the criminal defendant, you're offering it to say it's less likely I committed the act if the handgun belonged to someone else present at the scene. Is it a declaration against the person's then existing penal or pecuniary interest? As long as it is, it doesn't make a difference who offers it at a later point. And that's again, I think, a highly testable area, because you're thinking, oh, but this can't be a declaration against interest because it really helps the person now. It's against the declarant, the person who originally speaks it, against their then existing penal or pecuniary interest. 3 F's. Former testimony. Former testimony, right? Had to be subject to cross at the time it was given, but the interesting hook on that is subject to cross not necessarily by you, but someone with a similar interest to you in developing that testimony. Peter and I are in a car accident. I go first. I depose Sue. She's the eyewitness to the accident. Peter and I are actually both injured by a bus, we'll say. I go first. I depose Sue. Sue dies prior to... In my case, can we offer Sue's former testimony? Provided the bus company had the right to cross-examine that testimony at the time it was given, it would classify as former testimony. Easy enough. It's a hearsay, but it's going to fall into former testimony. In Peter's case against the bus company, try this. Can the bus company offer it, and can Peter offer that testimony, assuming either one of them wants to offer it? First of all, can we offer it against the bus company as former testimony exception to the hearsay rule? The answer is yes. And why is the answer yes? Because they had the opportunity to develop that testimony by cross-examination already, right? So against the bus company, it's easy. What about Peter? Okay, let's try it, the test. It's certainly hearsay. We're skipping to our exceptions. It's former testimony that either you had the chance to develop by cross-examination or someone with a similar interest to you. Aren't Peter and I in the same boat on that? So if I had the chance to develop it, we can offer it now against Peter as well as former testimony, even though Peter himself didn't get the chance to develop it by cross-examination. It's not necessarily you got to develop it, as long as someone with a similar interest to you got to develop it. Which, by the way, it's the opportunity for cross. If you choose to forego cross, for instance, at a probable cause hearing, on all likelihood, you had the opportunity, it still is former testimony. It's not a question of whether you crossed it, it's whether there was your opportunity for cross. Former testimony, family history, records of dates of birth, death, things along those lines. Which, by the way, if I asked you what your date of birth is, how would you know? Yeah, records, or someone told you. Your source of knowledge in all likelihood is hearsay, unless, those of you who can tell us, well, I have a firm recollection and all the rest. Huh? You were there. Yeah, you were there. You should be there. But it is, there is a real hearsay problem at its core there. Family history, former testimony, forfeit of a witness. That somehow you have helped this witness evade attendance at the trial or encourage them to, and therefore now, in fairness, you shouldn't be allowed to object to the witness's hearsay statements. It's a fairness principle more than anything else. Those are the unavailability exceptions. When the declarant's unavailable, I get those 5 in addition to all the others that are listed in 803, with one exception, which we know that one exception is when the declarant is not available, past recollection recorded, right? So if we have in our fact pattern and our answers here, past recollection recorded as one of the possible correct answers, and the declarant's dead or otherwise unavailable, scratch it out, right? It isn't possible that that's the right answer. If, on the other hand, we have some of the unavailability exceptions there, and that there's no showing that the declarant's unavailable, not possible that that's a right answer either. You scratch those out as well. If, though, we have gone to our unavailability exceptions, or not, depending on the declarant's availability, we still have a bunch of others to run. The largest group, or the group that happens most often, is what we call the spontaneous exceptions. What we have listed on our chart as present physical condition, present mental state, statement for the purposes of treatment or diagnosis, excited utterances, or present sense impression. Present physical condition. Someone's then existing physical condition. My knee hurts. That's actually hearsay, but admissible as a statement of then existing physical condition. Present physical condition comes in, regardless of who it's said to. Mm-hmm.
And the declarant states to the nurse, I was injured 6 months ago. Well, 6 months ago is not a present physical condition.
Agreed.
And so on that basis, it could not come in.
Nope. Not coming in as a present physical condition. It could still nonetheless be a statement for the purposes of treatment or diagnosis. Let's just look at the distinction between a couple of these here. Okay? Present physical condition, as its name implies, has to be present. Okay, I injured my back a while ago, and it still hurts. Maybe you can get away with that as present physical condition. But present physical condition must be present, okay? It can't be past. And present physical condition can be made to anyone. However, we have another fairly close one that talks about a statement for the purposes of treatment or diagnosis. And as long as it is a statement for the purposes of treatment or diagnosis, I can get past physical condition in, if it's pertinent to present treatment or diagnosis. Now, so if I go to the doctor and I say, I injured my back in a very serious car accident a month ago. Doctor, I really need some form of treatment because the pain is so intense. And the doctor writes that information in. Then that can become a statement for the purposes of treatment or diagnosis, even though it includes past physical condition. You know, other times you see past physical condition, up to the accident, my back was just fine. They record that. Of course, obviously, that's self-serving too. Well, I had no problems prior to the accident. Of course, you're going to say that. Past physical condition, if pertinent to present treatment or diagnosis, is a hearsay exception. It's got to be a statement pertinent to treatment or diagnosis. As long as it is, it comes in. Yep. It should be to a medical personnel, someone who can actually provide the treatment or diagnosis. You know, I had 18 beers before getting into the vehicle and driving home, before the car accident. Is that a statement for the purposes of treatment or diagnosis? You know, we can argue we can argue that the healthcare provider should know that you consumed alcohol prior to providing any treatment. I would certainly want them to know before prescribing any drugs the consumption of alcohol, and I think most of them would tell you that it's a question they ask in car accidents and the like, because you could have a concussion or you could just be drunk. Some of the symptoms mirror one another. Tony nods his head. Yes, Rachel. The statement should. Now, what? Well, she's saying, yeah, that's a good point. It's a at the time you say it, it's a statement of present physical condition. We don't have to worry about who it's made to. That's another distinction. Present physical condition doesn't make a difference who it's made to. I don't think, no. To answer what I think your question was, if you want it to be a statement for treatment or diagnosis, it's got to be the person seeking treatment or diagnosis. It's not supposed to be third or fourth hand, even though that's a great example, because I'm not sure what the answer is as we sit there and think about it. You'd almost say that there's a way we could get that fact pattern so tight that it should come in, but you're really at the fringe at this point. It should be the statement, should be the patient's statement, the person seeking medical diagnosis or treatment. Beyond that, then you've got your hearsay problems. Okay? Do we understand this? It's a small distinction. Present physical condition, by the way, see, to me, that's pretty straightforward. Present physical condition. Forget past. The only way I get past physical condition in is if it's a statement for the purposes of treatment or diagnosis. And you do see them load that up. You probably, as you already have, seen more than a few questions on that. And by the way, this fact pattern where, the ambulance chaser sends someone for treatment to the hospital, and you're sitting there saying, oh, please, if that isn't manufactured evidence. So you're going to tell me it's self-serving, and I thought we already discussed that this morning, right? The fact is, it doesn't make a difference that it's self-serving. The fact is, if it meets our test and we think it's sufficiently relevant, otherwise passes our 5-part test, it comes in. Whether it's self-serving and all the rest of it, your reasons for attacking it, that goes to cross-examination. My mother can get up there and testify that I didn't do it because I was with her. Is she likely to be lying? I hope so, right? But that doesn't mean we disqualify her as a witness. You don't, even though you know it's likely that they would lie, right? It's the way it works. Present mental state. This is either the Hillman doctrine or I'm feeling a little lightheaded, as Rachel said. And then you pass out. Present mental state. Or, more traditionally, the Hillman doctrine, present mental state, about something you intend to do. Declaration of then existing mental state about something you intend to do in the future. As long as it is about something you intend to do in the future, then it comes in, and it can even drag in past events. I think it was the Bojakis case in the textbook, which said, I've been paying him for protection, and I'm going to go give him another $10,000 tonight. So it went backwards and forwards, and that's okay as long as it contains a future event. The other case in the textbook was U.S. versus Feaster, where he said, I'm going down to the 7-Eleven to meet Angelo. He's going to give me a pound of dope for free. And then the kid is never found again. Larry Adair, I think was his name. And he's never found alive again. And they charge Angelo with murder. And they want to offer the victims declaration of their mental state about what they intended to do in the future. Meet Angelo to get the pound of dope for free. It came in. Why? Hillman doctrine principle about an act you intend to do in the future is admissible as such. Excited utterance and present sense impression. Very, very small distinction between the two of them. Each of those rules are really one sentence long. In order to have a present sense impression, the statement can be about any event you are then witnessing, as long as the statement is made while observing the event or immediately thereafter. So we got a narrow window as to when we can have present sense impressions. Excited utterance, on the other hand, the event must be a startling and as long as it's a startling event, the statement need only be made while under the stress or excitement caused by the event or condition. So we have a much bigger window on excited utterances, although we have a narrower group of events that could be classified as the event. It has to be a startling event, and then as long as it is made while under the stress or excitement caused by the event or condition, it comes in. So, an hour, sure. 2 hours, sure. Maybe the next day. Probably out at our outer limits. But some of these cases, we would argue that you could be under the stress or excitement for months caused by some of these situations. Now, you're pretty far out when you're trying to get months. But I don't have a problem with day. You've got to have the right fact pattern, obviously. But think of that. And the other thing is, when you have the two of them, present sense impression and excited utterance in the same answer, then look for the two distinctions. What's the event, first of all? Because if it's not a startling event, excited utterance is out. And what's the window? If it's beyond 10 minutes, it's probably not a present sense impression. Was there another question?
Yeah, I was trying to figure whether we could bring in that you said under the present tense impression earlier.
I said 2 hours. What?
But if it was, if I know within
Half an hour? The question is on the police sketch. How close in time can you get that to a present sense impression? I don't know. I mean, a sketch is going to take some time to get accomplished, and it's going to be some time after the fact. It says immediately thereafter, and immediately thereafter has been at least interpreted case law by a very, very narrow window. One of the questions we read says 10 minutes is too late. I actually disagree with the question because the whole sequence takes less than 10 minutes. But that's what they're working with as the outer limit. So the fact is, the best it gets on our examples about Brian, where he wants to make the ID, is it probably has to be, you know, the police officers find someone running from the scene 18 blocks away and bring them back to Brian and say, is this the guy? And Brian says, yeah. And then Brian, shortly thereafter, or even months thereafter, dies. Could that be a present sense impression? Yes, because we've now narrowed our window significantly. Maybe it's even an excited utterance under those circumstances. But a sketch, to me, takes up too much time. Arguably, you could create the sequence where you could get it, but I think a present sense impression is very difficult on the sketch. I just don't see that time frame. Maybe an excited utterance, if it was a significantly startling event, that, you know, if you were really beaten up or raped or something, you certainly could have an excited utterance that would last that long. My problem with the sketch is, sketch has to be done fairly methodically, I would think. So I just worry about the excited utterance. I'd worry much less about a selection from a photo array or a lineup ID under those circumstances. A sketch just seems to be much more methodical than we've got for a foundation here. Then we have our records exceptions. We lump it in here, past recollection recorded, which is really not per se a records exception like books and records and the like. Past recollection recorded, the reason it's the only hearsay exception which requires availability is because someone's got to get on the stand, the person that had the recollection, and they've got to tell us that they had a recollection. When they did, they reduced it to a writing or recording, that it was truthful at the time they did it, and that it doesn't help to refresh their recollection while looking at that now, but it is in fact accurate. At that point, you've established the foundation for past recollection recorded. Because the foundation is so detailed, that's why we need the person that actually made the recollection in order to get it. Once we establish that foundation, then don't lose it on the last portion of this. The person that is the witness who is offering the past recollection recorded, you don't have the right to just offer the thing into evidence. The witness has to read the past recollection recorded into evidence, or if it's a tape, it has to be played into evidence. It's just part of the rule. The rule is the opponent has the right to offer the thing, but the proponent cannot. Lastly, do not confuse past recollection recorded with recollection refreshed. Right? Past recollection recorded is a hearsay exception because we're talking about an out-of-court statement, the document, the tape, whatever it is. On refreshing recollection, we are simply talking about using something to reactivate the person's memory. And once reactivated, they can then get up there and testify as to what they know. And the thing that was used to refresh recollection is of no consequence whatsoever unless it was used to refresh while on the stand, and then you have a right to examine what was used to refresh. If it was used to refresh prior to taking the stand, then the judge has discretion as to whether you get to access what was used to refresh or not. Yep, right? That's just the last hook on past recollection recorded that we don't allow. It's just the rule, right? I mean, to me, it's a stupid rule, but the rule is the rule, that the person who wants to get the information that's contained in the past recollection recorded just can't then offer the thing as an exhibit. What they have to do is have the witness read it in, or if it's a tape, play it for the jury without offering the thing in. And the opponent has the right to offer the document or the tape into evidence. Just a little problem with the rule. The rules are very straightforward on spousal testimony. What you have to think about is originally, it really was a rule of disqualification. We didn't want spouses to testify against one another, period. And so at common law, spouses could not testify against the other in a trial. But the rule has advanced over time. And now when we look at it, anytime we're talking about one spouse potentially testifying against another or about another or regarding anything to do with the other, you've got to ask yourself two questions. And the first one really starts with, are we asking the spouse to testify about a confidential communication that the other made to them? If it's a confidential communication, and confidential communication under the Federal Rules of Evidence is either a statement, oral or written, okay? But it has to be confidential. That's the first part of it. It has to be confidential. if it's said in a room like this, my spouse comes in and screams out something at me, and you all hear it, that wasn't intended to be confidential. There is no confidential communication in that nature, and therefore, any of you who heard it can talk about it, and I can't, nor can she claim any privilege for that communication. But just because we happen to be with people doesn't necessarily mean it wasn't intended as a confidential communication. Jeannie comes in now, says, Michael, can I speak to you? We come over here. And she says quietly something to me. Michael, I just took $500 out of the cafe downstairs. You think that's okay? Right? She says something along those lines. You can't hear it, and I'm expected to hear it. That's a confidential communication. Right? It doesn't just have to be about the family. It can be about anything, as long as it's not joint criminal activity where you have the exception. Now, she says that to me. One of you has one of those super, little parabolic ears, and you're eavesdropping on everything, and you overhear that. Does that destroy the privilege? No. Right? You don't lose the privilege because of an eavesdropper. You do lose the privilege, though, even if there are children of the marriage who are of sufficient age that they can understand it. It is not a family privilege when we talk about communications. So you can't say things in front of your kids who are of sufficient age that they could understand it and still claim the privilege. The first test is it confidential. And then the second one is marital communication. Marital means we have to be married, obviously. Not premarital communications, not post-divorce communications, marital communications. Marriage that was valid in the jurisdiction in which you entered into the marriage. So Massachusetts doesn't recognize a common law marriage, but Kentucky does. If you were married in Kentucky in a common law marriage, should that privilege still hold even in Massachusetts? Yes. If it was a private marital communication, we recognize it. Now, how long do we recognize the privilege for confidential communications? Forever, right? Forever. And that's what they like to test now, remember, is the margins, right? So we have a post-divorce conversation that one spouse is just dying to tell the court about. Can the spouse talk about a confidential marital communication if he or she chooses over the other spouse's objection? No. Right? No. On the first part of our test, if it is a communication we're asking the spouse to testify about, and it was confidential, and it took place during a valid marriage, either can prevent the other from testifying about that communication forever. Forever. That's the rule. Now, we give them the highest level of protections because we want spouses to feel free to talk to one another about whatever goes on in their lives. Now, if it is not a confidential marital communication and we want a spouse to testify about other things, transactions or observations is what we usually describe that as. Something you either saw your spouse do or witnessed them do with someone else. That generally falls into the category of transactions and observations. In order to know whether a transaction or observation is privileged, the test is slightly different. What we have to know is a couple things. A, is this a criminal case? If it is not a criminal case, the analysis is over, there's nothing left to do, there's no rule on transactions or observations. B, is the marriage in existence at the time of trial? Now you'll note that that's a slightly different test than on communications. Communications, we worry, was the marriage in existence at the time the communication was made. On transactions or observations in a criminal case, the key is the marriage in existence at the time of trial? If the answer, again, is in the affirmative, yes, it's a criminal case, yes, the marriage is in existence at the time of trial, then the rule is SEFW, right? State court, either spouse, party spouse, the criminal defendant spouse, or the witness spouse, can prevent the other from disclosing any information, period, any. Premarital communications, marital communications, observations, transactions is what we call a rule of disqualification. That witness will be prohibited from testifying, just like at common law. In the federal court, if the case is in the federal court, then that right belongs to the witness spouse only. Federal court, the right belongs to the witness spouse only. Now, we're in federal court on a criminal charge. Marriage is in existence at the time of trial. Possession of cocaine with the intent to distribute is the charge. My wife sees Brian and I in the driveway of our house. She sees me open up the trunk, take out a big bag of white powder, give it to Brian, and take a wad of bills like this and bring it into the house. And she says, "What were you and Brian doing down there?" No one else in the house. I say, "Well, I just had to sell Brian some cocaine in order to pay the mortgage this month." "Okay, honey." So I'm arrested, charged with cocaine with intent to distribute. And government calls her. Federal court, possession with intent to distribute. Government calls her. Criminal case. What can she testify to over my objection? What's your first question? What's your first question? A criminal trial, right? It clearly is a criminal case, so there's the answer is this. And your second one is what? Is the marriage in existence at trial? And assume it is. Okay, we'll assume we're still married. Assume it is, and we already said it's a criminal case. So now we apply our rule. State court, either spouse, but we're not in state court. Federal court, witness spouse can testify. So if she chooses to testify, for whatever reason she wants to disclose the information, then the question is, what can she disclose? First, can she disclose the things she observed from the window that she saw in the driveway? Yes, right? Even over my objection. Why? Because in the federal court, that right belongs to a witness spouse. Then, the government says, and what did he say to you immediately upon returning to the house? Objection, right? What's your objection? What about hearsay? First, let's try, okay, you've got privilege and hearsay. What about hearsay? Is it an out-of-court statement? Offered to prove the truth of the matter asserted therein. I sold Brian some cocaine, we needed to pay the mortgage. Yes. So it's hearsay unless it's a party's own statement, right? I am the criminal defendant, I am a party. Who is seeking to offer the statement? The adversary, the government, and it's offered through anyone who heard it. Non-hearsay, party's own statement, what is often referred to in the text as an admission. An admission is a real misnomer, and we'll get to that later. But this, in fact, is a party's own statement that the adversary wants to offer. It is admissible as an admission. You jump to your feet again, say objection, privilege. Claiming it on behalf of the party spouse, right? Can the party spouse, even over the other spouse's objection, can I claim privilege for that communication that took place during a valid marriage? Yes, right? Yes. The communication stays out. Let's try one last loop on this fact pattern. We're divorced. We're divorced. Same, everything else is the same, now, except now she wants to testify, say. The government doesn't have to call her. She's more than anxious to get up there and wrap me out on the stand. So she's on the stand. What, if any, privileges attach? Only the communications, right? Why? Because when we do our test on transactions or observations, is it a criminal case? No, done. We don't even have to go any further with it. There is, under those circumstances, there's no privilege for transactions or observations. The only thing that's left are private marital communications, and assuming it's claimed, even post-divorce, you have the character evidence is not introduced. It may not be introduced to prove that the defendant acted in conformity with a specific character trait. It doesn't come in to show, in essence, that someone has a propensity to act in a certain way. You know, that's the argument that if someone's been convicted earlier multiple times of rape, or even once for rape, and the present charge is rape, then we can show those prior convictions to say, once a rapist, always a rapist. He has a propensity to act in a certain way. That's not why we introduce character evidence at all. Character evidence is generally always only a criminal case issue. Okay, so when we're looking at a fact pattern, the first thing we should start to think about is it a criminal case where we're seeking to introduce character? And if not, it is very, very rare that character is relevant in a civil case. If you look at the handout, it talks about malicious prosecution, libel, and slander are a couple of the examples where character evidence would be relevant. Why? Because the person is generally saying that their character has been damaged as a result of the defendant's action. And under those circumstances, obviously, if you're saying your character has been damaged and you were a pretty rotten character before that, then it becomes relevant as to the level of your damage. But beyond those cases, it is quite rare that character evidence is an issue in the civil case. So if we look at a fact pattern and it's talking about character evidence in a civil case, you say, geez, that's highly unlikely that that's admissible. When is it admissible? Malicious prosecution, libel, slander. Then when the civil action has something to do with the person's character. Okay, it's a pretty straightforward rule. And so then the other rule is on criminal cases, it can be an issue. But even in criminal cases where character is an issue, it isn't an issue at all until the criminal defendant places it an issue. So if we're looking at a case, and it talks about the government is introducing character evidence in a criminal case, in their case in chief, it is highly unlikely that that's admissible. Why? Because the criminal defendant hasn't placed it an issue in the case. Criminal defendant's case hasn't even come up yet. They really can't make their character an issue until they're presented some form of evidence of their character. So character evidence is really a criminal case issue, and it isn't an issue at all until the criminal defendant places it an issue, and the criminal defendant places their own character an issue by offering witnesses to testify as to what their general reputation is in the community for relevant character traits. Okay, relevant character traits. And what they're going to do is they're going to call a few people in the community who know their reputation. Suppose it's an assault and battery offense. They want to get a few people up there that know them and say, and this is the way you would in fact do it, I know their reputation in the community. I've lived here, I know it. They're known in the community as a peaceful, nonviolent person. What they are doing is offering general reputation evidence only of character that's inconsistent with the crime charged. That's what makes it relevant. If it's an assault and battery offense, then they have the right to offer character evidence that's inconsistent with that charge, peacefulness, nonviolence, through general reputation witnesses only. Once they do, though, once they have offered that character evidence, then it's fair game, and then it becomes a legitimate issue for the government to try and attack. And the government can attack it in a couple of ways. One of which is to ask those witnesses who just testified about specific instances of conduct that are inconsistent with what they just said. I know you just said that he's known in the community as a peaceful, nonviolent person. Did you know, though, that he one time beat Gene with a bat so badly Gene was hospitalized for 2 months? Oh, geez, I never heard that. So now we're plumbing the depth of the knowledge, the breadth of knowledge they have, and we're seeking to impeach the character witnesses. And we can do so through specific instances of misconduct inconsistent with the character evidence that they've offered. That's the only time we really use those specific instances on character. The prosecution may also seek to rebut the defendant's evidence of good character by offering other character witnesses. Okay, you called 3 that know you in the community. I'm going to call a couple that know your reputation in the same community, and they're going to say, oh no, he's known as a real rough, tough guy that would snap at the drop of a pin. That's his reputation. You don't cross Gene, you don't cross whoever, because they're known in the community as a very violent person. The government now, the criminal defendant now having made it an issue, the government has the right to attack that character evidence with other general reputation testimony. Okay? Never, almost never do you see character evidence offered in a civil case. Now, a related rule when we start to talk about character. It's character for truthfulness. civil or criminal cases. The character for truthfulness shouldn't be confused with general reputation type character, right? Everyone who takes the stand, civil or criminal case, has placed their character for truthfulness in issue. Now that should be pretty logical to you, right? If someone gets up there and swears to tell the truth, the whole truth, and nothing but the truth, and there are events in their lives that say, this person is a big fat liar, then all that evidence, or at least most of it, should be available for impeachment. And that's the rule, right? If you take the stand, you get up and testify, and you swear to tell the truth, that on cross-examination now we can plumb your character for truthfulness. We can plumb how truthful of a person you are. And again, I can do that in multiple ways. I can offer character witnesses to say he's known as a liar. That's why we're offering it now, as a liar. I can offer specific instances of misconduct that are probative of truthfulness. Isn't it true you once stole $1,000 out of the church box when you were there? And also through prior criminal convictions, which we're going to get to momentarily. Prior criminal convictions, whether they are probative of truthfulness or not, all convictions, I have the right to offer, and if it's a crimen falsi, I have an absolute right to offer it if it's less than 10 years old. And we'll get to the rule on impeachment with prior convictions momentarily. We always confuse habit with character. Even the handout, unfortunately, lumps them together. The books always do, and they really are quite distinct. But we have a tendency to do it, and the handout probably further perpetuates that problem. Habit, however, is very, very different than character. Habit really says, well, habit, first of all, is almost always civil. So that's another way to separate them. Habit, civil. Character is almost always criminal. You prove habit, unlike character, where you prove character by general reputation only. What have you heard? What do you know about this person in the community? Habit, we prove by specific instances of that behavior. In order to get the foundation in for habit, you have to show specific instances of behavior, and a bunch of them. And that's what makes it a routine, and a routine is what makes it habit. What's habit? Every time when we did hearsay, he put that damn chair on the table. Right? Routine and systematic behavior. When a letter is received in the office, first it's date stamped, then the envelope is opened, then the letter is stapled to the envelope, and then they go into filing. We do that on Monday. We do that on Tuesday. We do that on Wednesday. We do that on Thursday. We do that on Friday. The routine practice becomes habit. Because it's habit, we think it's relevant to show that a person acted in conformity with their habit. That's the rule. So habit is almost always civil. Habit, unlike character, is proved through specific instances of conduct. And habit actually does come in to show that the person acted consistent with the habit that they have. If you separate them fairly rigidly, they really are quite different. The problem is when you see them in a fact pattern, there's almost always one of the answers says character and one says habit. And you say, I have no remembrance of what he told us this was about. So remember the general rules. Criminal case, more likely character. Civil case, more likely habit. General reputation, character, specific instances, habit, and then take a look and see what they're trying to do. You know, remember, even in the cases where character is admissible, it isn't admissible till the criminal defendant places it in issue by offering character evidence. Let's try a quick example of that. Criminal defendant is charged with assault and battery. Gets up on the stand and testifies, I didn't do it. Offers no other testimony or witnesses. What, if any, portion of the defendant's character is an issue in that criminal case? Right? Only the character for truthfulness. Only the character for truthfulness. So if that's all the defendant did, the government could attack his character for truthfulness. But what they could not do is call witnesses to say he's known in the community as a very violent person. Why? Because that defendant has not placed that an issue. On the other hand, if the defendant gets up there and testifies, or better yet, doesn't testify at all, understand that part of it. Criminal defendant doesn't testify, for whatever reason chooses not to, for various reasons you could probably imagine, chooses not to testify. Nonetheless, calls 3 witnesses to say he's known in the community as a very peaceful, non-violent person, wouldn't harm a fly. Now, what portion of the defendant's character is an issue, if at all? Not all. His character for peacefulness and violence. Right? Why hasn't he placed his character for truthfulness an issue? Because he hasn't taken the stand. Right? We don't care whether he's a liar or not at this point, because he hasn't said anything. But he has offered and can offer his general character, as he has done, and at this point, we can impeach it, and the government can impeach it either through other character witnesses who are going to get up there and say, oh no, he's one dangerous dude, or his prior bad acts when we talk to those witnesses about the specific acts that are inconsistent with what they just said. All of that at this point is fair game. Why? Because the criminal defendant has made his or her character an issue in the case. Yep?
I just want to be clear. Reputation and character are the same thing?
Yeah, well, reputation is the manner in which you prove character, and for that reason, then, your reputation with respect to the specific charges, whether it's violence, drunkenness, whatever it is, that's the reputation we want, and it is reputation / your character reputation. Yes?
Can you slide that into habit for a civil case for damages the same type way you just did?
Mm-hmm. Sure. Try this. When I smoked, right? Every day after class, as soon as class was over, Professor Coyne would run out, grab a smoke, jump in his car, and speed down Federal Street, God knows where, but he was going somewhere. Right? How do you know? Well, I saw him do it on Monday. I saw him do it on Wednesday. We had class a little later on Friday, so he did it later, but he did it again. Now, someone is hit allegedly by my car speeding down Federal Street. What they want to do now is sue me for damages, and they need to prove negligence. And so they want to show that Professor Coyne was speeding while driving down Federal Street and inattentive because it looked like he was smoking a cigarette. Now, they want to offer evidence of negligence. Well, they could offer someone who saw me specifically speeding and say, well, I saw him, he was going real fast, right? Speed is one of the things lay witnesses can testify to. Or, does that less convincing to me, but nonetheless admissible under the rules of evidence, they could call one of you that had me in Civ Pro or evidence when I did smoke and say, listen, every day after class, he jumped in that car, lit a smoke, and sped down Federal Street, God knows where. That's habit. And now you've shown habit because every day, how many weeks did you have him? 15 weeks. How many days a week did you have him? 3 days a week. 3 days a week, 15 weeks over the course of a semester probably establishes habit for at least that semester. You know, arguably we could say, well, he stopped smoking or whatever to terminate the habit. But at this point, you've established habit, a routine practice.
But I didn't have to wait for you to bring that in.
No. Habit is not like character where it's only an issue when it's made an issue. Habit, you have the ability to offer habit in the plaintiff's case. Habit can come in if you can establish that it's a routine and systematic behavior that someone has engaged in. That's what makes it admissible. Why? Because people act then consistent with their habit. You know, whatever it is they do, and you know, cigarettes are a bad example because you think of that type of habit, but quite often habit really is business practices, things of that nature. Have you ever been in an office and we date stamp envelopes, or whatever we do, the business practices we have as a regular matter. Outgoing mail, same way. You know, when we receive a check, we immediately draw up a deposit slip. We do this, we do this, we do this. You know, those are habit. Routine and systematic behavior becomes habit, and the law says that we generally act consistent with the habits we've established, and that's what makes it relevant. And you don't have to wait till someone else places an issue. You have the ability to offer that evidence of habit. Okay? Turn over the sheet and let's think about when we talk about character and habit is also generally tends to be lumped together with impeachment. And so when a witness testifies on the stand, we need to know what methods are available for impeachment. Now, we know one way is their character for truthfulness has been placed in issue when they've taken the stand. But we also know the scope of cross-examination under the Federal Rules of Evidence is B, C, D, right? Bias, credibility, and the subject matter of direct. The subject matter. Just because this question or this tape wasn't used on direct doesn't mean I can't use it on cross. It is the subject matter, which is a fairly broad area for cross-examination. The subject matter of direct. Bias. If you are related to the party or have a relationship to that party, that creates a bias. If you have been paid to testify, paid for some work on the case, have a financial interest in the outcome of a case, that goes to bias. As of right, I can inquire into bias. And what that means is that it would be reversible error for the judge to cut you off with respect to a legitimate question of bias. You know, reversible error is always how you get the judge to pay a little more attention to your argument when you make that. And bias specifically would go to, as of right, I can inquire into bias, and it would be reversible error not to allow that. You can impeach any witness by showing that his general reputation for truthfulness is bad, by his prior criminal convictions, and by his prior bad acts that bear on truthfulness. So someone who testifies has placed their character for truthfulness in issue, and at this point it is subject to attack in a number of ways. If the witness has been convicted of a previous offense, and remember, at common law, a witness who was convicted of a crime could not testify. And the reason for that is most good, decent people have never been convicted of crime. At least that's the theory, which I think is more right than wrong, right? And so if that's the theory, then at common law we said, well, if you were ever convicted of any offense, that probably renders you somewhat untrustworthy. And therefore, we don't choose to have your testimony anymore. But the modern rule has advanced, and the drafters of the Federal Rules of Evidence have decided that we want to encourage people to testify, but we also want the jury to understand that there may be things that they should consider regarding this witness's testimony that they should weigh carefully in deciding whether to accept it or reject it. So then the rule became, if you were convicted of perjury, you shouldn't testify anymore, which that's not a bad rule either if you think about it. Most of us have never been convicted of perjury, and if someone would lie under oath once, why wouldn't they do it again? But even that rule gave way to say, well, that's still pretty harsh. What if that was your only witness you had in a murder defense case? Don't you have some right to call witnesses on your behalf to testify? I mean, maybe we ought to modify that rule as well, which gave rise to the present rule. If it is a crime involving what's known as a crimen falsi, a crime involving a false statement or dishonest act that the witness has been convicted of, any witness, criminal defendant, any witness, it's less than 10 years old, and less than 10 goes from either the last date of incarceration or conviction, whichever is later. We don't care about the case pending on appeal. We don't care that they got probation for whatever the offense is. We look at the date of conviction or last incarceration, whichever is the more recent date. If it's less than 10 years old, the court has no discretion to exclude that prior conviction. That's a very straightforward rule. And that's testable because quite often we give the trial court discretion to exclude or do just about anything. So when the trial court's hands are tied, that's a good testable area because that's unusual. So if it's a crimen falsi, crime involving a false statement or dishonest act, less than 10, the trial court has no discretion to exclude that prior conviction. But we understand now, you've got that rule down, but that rule, when we offer convictions at all, we only offer them to say that the witness is a liar, right? Don't believe this witness. So the witness has to testify. Okay, that might seem self-evident to you, but quite often they draw up a question so that the witness hasn't even testified. and you see a criminal fallacy, 3 years old, you say, damn it, I remember that one. They can't exclude it. It isn't even admissible yet. The witness has to testify. So don't get tricked into saying, I know the rule on criminal fallacy, no discretion to exclude. Only when the person has testified. So the person hasn't testified yet, or it's the government's case in chief, you cannot offer that criminal fallacy yet. The person has to testify. Because that's why we offer prior convictions, is to say they're a liar, not to say they're the type of person that commits crimes. So, if it is some other felony less than 10, and it's a felony, it's not misdemeanor, it's a felony. So if you had a misdemeanor criminal fallacy, that's okay. But any other misdemeanor doesn't count under the Federal Rules of Evidence. Okay? It says felony. Any other felony less than 10, then you've got to look at the rule carefully because it's a little tricky. All other felonies are subject to what we call the 403 analysis. 403 analysis unless it's a prior conviction of the criminal defendant. And then it is excluded if it is more prejudicial than probative. Just a simple balancing test if it's the criminal defendant. As opposed to the substantially more prejudicial than probative analysis required to exclude convictions of all other witnesses. So we have a little test as to whether who's the witness testifying on other less than 10 felonies. Is it the criminal defendant or is it some other witness? If it's the criminal defendant, then we can exclude that prior conviction if it's more prejudicial than probative, and if it's some other witness, then we can exclude it if it is substantially more prejudicial than probative. Now, let's try a couple of examples. We have a present charge of rape. No, assault and battery. We have a present charge of assault and battery. We have 3 prior assault and batteries committed in various manner. One with a shod foot, one with a baseball bat, one with just your fists. Present charge is assault and battery, just plain old assault and battery, got into a fight somewhere. Person doesn't testify. Which, if any of those prior convictions can come in? None, right? There's no testimony at this point. There's nothing to impeach. You can't use the prior convictions to impeach. Why? Because there's no testimony to impeach. Good. Okay? Person gets up there and testifies. Says, no, the other guy started the fight.
Is that the defendant?
Defendant gets up there and testifies that the other party started the fight, not me. Now, on cross-examination of the defendant, try the first question. May the trial court exclude those 3 prior convictions if offered for impeachment purposes? Yes, right? Why? Because we have to, first of all, is it as of right that I can use those 3 prior A and B convictions? No, right? They're not criminal falsies. They are crimes that are marginally relevant on credibility. That's all they're offered for. But they are certainly not criminal falsies where I have an absolute right to offer them. So we go into the 403, well actually we said the criminal defendant, the balancing test. Now, are those 3 prior convictions, if offered, attempted to offer them for impeachment purposes, could, call of the question is, could the court determine that it would be appropriate to exclude those 3 prior convictions? Yes, right? And the answer is, if the answer even was should the court exclude the 3 prior convictions, the answer is probably yes. Why? Because when we do the balancing test, that are they more prejudicial than probative, more harmful than relevant, that's what you're saying, the question first becomes, why are they relevant? The only reason they're relevant, or at least that's the reason we're putting forward, is to say the person's a liar. Well, isn't it likely that the jury is going to look at those 3 other convictions for A and B and say, he's just a brawler. He doesn't know how to behave himself. We're going to convict him here. Under those circumstances, this analysis really says those 3 prior convictions should be excluded. Why? Because they're only offered for impeachment, and the fact is the jury is likely to use them for much more than impeachment. Therefore, the better course would be to exclude those 3 prior convictions. Now, try a slightly different example. Person is presently charged with mail fraud. Right? Mail fraud is the present charge. The person has 8 prior convictions, 4 for mail fraud, 4 for perjury, all less than 10 years old. Person gets up there and testifies, I didn't do it. Cross-examination. May the trial court exclude the 8 prior convictions, all less than 10 years old? No, right? Why? Because that's the rule. The rule says less than 10, crim and falsy, no discretion to exclude. Now, is the jury still likely to misuse the prior convictions? Yes. It doesn't make a difference. The judge's hands are tied. It's one of the few times where we don't give them the discretion to exclude. So it's a good testable area. Why? Because they don't have the discretion. It cries out to say, no, throw at least some of them out for God's sakes. He's going to be convicted regardless of what the evidence is this time. It doesn't matter because the rule doesn't give the judge that discretion, even though they're likely to misuse the prior convictions. So we make our analysis. Is it a crim and falsy less than 10? If it is, no discretion to exclude once the person has testified. None. If it is some other felony, then we weigh whether it should be admissible either on 403, if it's some witness, or simply more prejudicial than probative, it should be excluded if it's the criminal defendant. What's interesting about this is, once we get past crim and falsies, the more similar the prior offenses are to the present charge, the greater the reason we should exclude the prior convictions. It really goes completely against what a lay person would think would be relevant. Well, that's good, okay? Because you're not lay people anymore. You're lawyers. And that's what the bar exam tests, law. So we just have to remember what the rule is and then apply it. Lastly now, we're beyond 10, right? We're beyond 10 years. Now that's a long, long time. Beyond 10. And again, the 10 is from the date of last incarceration or conviction. So I'll give you, for instance, someone is convicted 15 years ago of perjury, does 6 years in jail. Now, I know you're not math majors, but does that count as a more than 10 or less than 10 offense? Less, right? 15 minus 6 gives us 9. Okay? The date, whichever is the most recent date, is the date you use. Okay? If it's 15 years and they served 3 years in jail, more than 10, it's a 12-year-old offense now, right? And we go to a separate set of rules. Every crime, crim and falsies, felonies, everything, are subject to a 2-part analysis. The government, or whoever, has to give advance notice of their intention to use the offense. So if you don't see that in the fact pattern, no advance notice, out it goes. And straight across the board, it's excluded if it's more, simply if it's more prejudicial than probative. You got advance notice, and you must show, and by the way, it says a ruling supported by specific acts. The judge actually has to write up a specific memorandum saying that this rule has been satisfied by specific facts and circumstances showing that the probative value of the conviction substantially outweighs the prejudice. Think about that. That says that the policy really is against admission at that point. So it's a very difficult way of having to get in what the law sees as stale convictions. Do you have a question? Go ahead.
The difference between the accused and witnesses brought up, you bring up a witness who says that you're not a brawler. Then you...
Okay.
You got the accused. He offers a witness. He says, no, this guy doesn't fight. He's a peaceful guy.
Okay, you're going back to character now.
No, I'm using, but he's been convicted in the past of brawling.
Who has?
The accused.
Oh, okay. Actually, I hear what you want. I think I know where you want to go. Okay, so the criminal defendant puts character witnesses up there. Right. And the criminal defendant has these witnesses are prepared to testify. He's known in the community as a peaceful, nonviolent person. Right? That's the test. That's the testimony that the defendant's witnesses have offered. Now, just follow the rule before, you don't need to make it complicated, I think, if you remember what the rule is. At this point, that character evidence has been admissible and can be impeached in a couple of different ways. Either through other witnesses, call these guys and say, no, he's known in the community as a very, very violent person. That's one way. Or, when Gene got up there and said he's known in the community as a very nonviolent person, I have the right to inquire of Gene, to test the breadth of Gene's knowledge about this person, and to ask him about specific instances of conduct that are inconsistent with what he just said. And Peter wants to say, well, what about a conviction then for assault and battery? Absolutely. I mean, the fact is, what's interesting about character evidence or impeaching witnesses on character evidence, I don't even need the conviction in order to use it. Isn't it, did you know, I heard what you just said, Gene, but did you know he once beat up a person so badly in a bar that the gallons of blood flowed across the barroom floor? I don't need a conviction, I don't need a charge, I don't need anything. I need a specific act that's inconsistent with what they just testified to. Conviction, all the better, right? I heard what you just said, but did you know he was once convicted and sent to Walpole for 5 to 10 years? God, I didn't know that, right? I mean, now we're testing the depth of that knowledge. So, with or without a conviction, I have the right to impeach the character witnesses on specific instances of conduct inconsistent with what they just testified to. By the way, those character witnesses that got up there, and said, no, Gene's known as a peaceful, nonviolent person. So not only can I plumb the depth of the character they just talked about by impeaching through specific acts of misconduct, I can say, sir, isn't it true that 3 years ago you were convicted of mail fraud? Right? That witnesses their own character for truthfulness that placed an issue as well. Right? So witness gets up there, character witness gets up there. Let's just simplify it because now we may be, I see a few confused faces. Character witness gets up there, says, I know Peter Unit's reputation in the community. He's known as a peaceful, nonviolent person. Okay? Now, that witness is fair game in a number of different areas. I can ask that witness about specific instances of Peter's conduct that's inconsistent with what the witness just testified to. I can ask that witness with respect to the witness's own bias. Maybe Peter has paid him to testify. Maybe he works for Peter, God knows what. I can ask that witness about that witness's own specific instances of misconduct that are probative of truthfulness. And I can ask that witness themselves about their own acts, convictions, for either mail fraud as of right or other criminal convictions. So there's a whole ton of ways that character witness can be impeached with respect to things they've done in the past. That's all fair game under the rules. Yep?
Can you give us an example of a felony conviction where the probative value would substantially outweigh the prejudicial effect?
I think it's the crimes that are too similar. You've got 3 rapes committed in various fashion, and the present charge is rape. And the fact is, you know, common sense says the jury should at least get to consider, to me, that common sense says the jury should at least get to consider those other offenses. But the rule says, and it's true if you think about it, the rule says that the jury is highly likely to use those offenses not to say the person's a liar, but to say that they're a rapist. And that it's not fair under those circumstances because the law says that that's not a legitimate basis to offer those prior convictions. So that's what you're talking about, is when the felonies are too close to the crime charged, they really should be excluded. Now we've got one last loop here we want to do with respect to other acts and things like that, which is what we call, when we want to offer other acts that the defendant has committed at some point in time, it's what we call the brides in the bathtub rule, the signature crime rule, the serial killers rule, whatever you want to call it. What you have to think about is that these prior acts, again, we don't need convictions, we need acts, that they somehow provide a link to the present charge to something that took place earlier. And usually, we have to show that they show us a link to either motive, opportunity, intent, common plan, scheme, design, lack of mistake, accident, or identity of the perpetrator. The prior offenses have to be done in such a way that they either provide, a signature offense, so that we clearly show that this offense was likely to be committed by them. Whether it's the Boston Strangler who would take the pantyhose and tie them in a specific way in a knot around the victim's throat, or the accidents that happened in the bathtub 3 times to this young guy who married a very wealthy older woman, and at some point it isn't an accident when the same thing keeps happening, or even if it is at least a factor for the jury to consider that the prior offenses, the prior acts, not even offenses, we don't need criminal charges of any sort, that they come in, and they come in during the case in chief. So the defendant doesn't have to testify, it's not a character issue, the defendant doesn't have to offer character evidence. Those prior acts are coming in because they show an identity of circumstance.